Good morning, and welcome to the UVA Law Federalist Society's 5th Annual Originalism Symposium. My name is Trevor Hogendorn, and I've had the pleasure of serving as the Symposium Chair for our chapter this year. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It's founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is the province and duty of the judiciary to say what the law is, not what it should be. This year's symposium, titled History at Work, Text, History, and Tradition Applied, will explore some ongoing debates in originalist jurisprudence since the U.S. Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruen. Bruen itself was certainly an important Second Amendment decision, but the methodology that the Supreme Court used raises a lot of important questions for originalists. Especially as the court continues to emphasize history and tradition in constitutional interpretation, it's important to know what that means and how to put it into practice. My hope is that you will walk away from today's symposium with a better understanding of those ideas. Our panels today will explore topics like the development of the law since Bruen, the appropriate role of post-ratification history, the practical challenges of using history and judicial opinions, and what history is relevant when interpreting constitutional rights incorporated against the states. Before we begin with our first panel, I'd like to extend my gratitude to several people. I first want to thank the national staff of the Federalist Society for their sustained support of our chapter and their help in making this event possible today. Thank you to Aquila Maliakal, our chapter president, and the rest of the outgoing board for their help in generating ideas and volunteering their time to help the event run smoothly. Thank you to our speakers for sharing your time and expertise with us today. And thank you especially to Professors Bomzai and Mahoney for being sounding boards and mentors over the past year as this event has come together. Thank you to all the folks at the law school for their help in coordinating this event, especially the people in building services, IT, and communications. Thank you to Faith Chudkowski for your tireless efforts in marketing. Chances are, if you all see something aesthetically pleasing today, she's the one that made it. And finally, thank you to the members of the Symposium Committee, 1L's Andrew Odell, David Bainbridge, Juliana Kantner, and Thomas Ross, who helped plan, coordinate, and execute every facet of this event. Now on to the first panel. I want to first let you know, in case you didn't hear the announcement from Zoom, that today's panel is being recorded, and by attending, you consent to being filmed and the use of your appearance in connection with this event. Our first panel today is titled Text, History, and Tradition on Bruen's Second Birthday. In Bruen, the Supreme Court held that New York's may-carry licensing regime violated the Second Amendment. Rejecting the use of means-end scrutiny in the context of the Second Amendment, the court put the burden on the government to prove that its firearm regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. As we approach the second anniversary of Bruen, a few questions present themselves. How has the court's focus on history fared, particularly in the context of the Second Amendment? Are there unexpected pitfalls in the search for historical analogs? And how have lower courts applied the test? To help answer these questions and others, we have a panel of 3 outstanding professors. The panel will be moderated by UVA 1L and member of the Symposium Committee, Andrew Odell. And I'll turn it over to him to introduce our speakers. Please join me in welcoming our panelists.
Thanks, Trevor. Good morning, all. It's my privilege to introduce our 3 distinguished panelists with us today who will help us tackle these questions. Professor Josh Blackman is a professor of law at South Texas College of Law of Houston, where he also holds the Centennial Chair of Constitutional Law. Professor Blackman teaches property in various constitutional law courses. He's also an adjunct scholar at the Cato Institute and the author of 3 books and more than 6 law review articles, many of them about various issues of constitutional law and interpretation. He is just as prolific online as a frequent contributor to the Volokh Conspiracy. He earned his JD from George Mason Law School. The other Virginia Law School. Next, we have Professor Fred Schauer. He's David and Mary Harrison Distinguished Professor of Law at the University of Virginia School of Law, where he teaches constitutional law to 1Ls like myself and various courses on the First Amendment. He earned his JD from Harvard Law School and cut his teeth in the legal profession as an obscenity lawyer. He is the author of a number of books translated into many different languages, and he has written widely on freedom of expression, constitutional law and theory, and legal reasoning and the philosophy of law. He has also written on analogical reasoning with his wife, Professor Barbara Spellman, and one of their law review articles on the topic was cited by the court in Bruen. And rounding out our panel, we have Professor John Harrison, who is the James Madison Distinguished Professor of Law at the University of Virginia School of Law, where he teaches federal courts, remedies, civil procedure, and more. He also writes on issues of administrative law, constitutional law, and constitutional history. He earned his JD from Yale Law School, where he served as an editor of the Yale Law Journal. Before joining UVA, he clerked for Judge Robert Bork on the DC Circuit and served in the U.S. Department of Justice in a number of roles, including as Deputy Assistant Attorney General in the Office of Legal Counsel from 1990 to 1993. We'll hear from each of our speakers for 15 minutes. We'll have 15 minutes for them to interact with each other, and then we will open it up to audience questions. Professor Blackman.
Thank you so much. Good to be here first up at bright and early in the morning. In the span of 2 years, the Supreme Court decided two landmark Second Amendment cases. D.C. v. Heller in 2008 held the Second Amendment guarantees an individual right to keep and bear arms that is not connected to militia service. 2 years later, McDonald v. Chicago applied this right to the states through the 14th Amendment. The precise holding of both cases, though, was limited to the question of whether the federal and state governments could prohibit the private ownership of firearms inside the home. Heller and McDonald did not address the broader question of carrying outside the home. We'd have to wait 12 years, it's a long time, before the court would resolve that issue and settle a circuit split. In 2022, New York State Rifle and Pistol Association versus Bruen held that the Second Amendment protects an individual's right to carry outside the home. That's the easy part, and the holding was perhaps not too controversial. What's controversial is the methodology by which they got there. The court has leaned in heavily to this tripartite framework of text, history, and tradition. Indeed, one of the biggest progenitors of this was actually Judge Kavanaugh. When he was on the D.C. Circuit, he decided a Second Amendment case involving different types of weapons, and he decided it based on this concept of text, history, and tradition. And the test is this: the government has the burden to prove that a firearm regulation is part of a historical tradition that delimits the outer bounds of the right to keep and bear arms. Historical tradition. If you look at Bruen, it's this sort of historical journey where the court starts more or less in the Middle Ages, goes through English common law, into the colonies, into the antebellum era, into the post-bellum era, we don't really talk about that too much, into the laws in the Western territories, and then more or less petters out when New York enacted Sullivan Law in the early 20th century. You might ask, why is the court looking at this sweep of history that predates the Constitution and that postdates ratification by many, many years? Justice Barrett wrote a concurring opinion, and she joined the majority but said, look, I'm not sure. There's an unsettled question. And she asks, how long after ratification may subsequent practice illuminate original public meaning? In other words, the Second Amendment ratified in 1791. And then maybe we look at the 14th Amendment in 1868, so maybe those are two temporal positions. But why are we looking at, laws in the Western territories of Wyoming, right? Why are we looking at all this post-enactment history? And Barrett seems to be raising a question about the third leg in this tripod: text, history, and tradition. The court has actually applied this framework in a lot of other cases. For example, in the context of abortion, in the Dobbs decision, which I'm sure we all know about, Justice Alito looked to the types of abortion laws when the 14th Amendment was enacted. Is there a tradition of permitting abortion and some sort of right to have an abortion? The court has used this standard in the Establishment Clause context. For example, in American Legion, right? Was there a memorial that's been up on display with a cross in it? Town of Greece versus Galloway, a prayer before legislative meetings. In all these cases, the court looks to what is the tradition, right? Not so much what was existing in 1791, but what has been done since then. I think what we're seeing really is this sort of this fragmenting of originalism, and it's perhaps not anticipated, but it's happening. I think the leading critic of the tradition approach has been Judge Kevin Newsom, who's a judge in the 11th Circuit. And even before Bruen, he wrote a concurrence in a case called U.S. versus Jimenez Shilon, S-H-I-L-O-N. And he said, wait a minute. Okay, I get text, right? We're all textualists. That's what Justice Kagan tells us. And even with the Constitution, we're still textualists, right? Scalia said, I look for the same thing in the statute as I do in the Constitution. What is the meaning of the text? Okay, so we're textualists. Number two, history. Okay, we need history, right? To inform the meaning of a text, we look to how that text was understood. So I don't think anyone disagrees with text and history. But where does tradition come in? Judge Newsom suggests that this concept of tradition is duplicative, right? That it doesn't really add much beyond what text and history provides. Or does it? Or does tradition allow you to look at what Judge Newsom calls latter day, but still kind of oldish, oldish, right? I like that. Understandings, like ye old England, right? His oldish understandings, and it misdirects the inquiry. Okay? Another leading critic of this sort of traditionalism is Sharif Gurgis, who's a professor at Notre Dame. And he says if the court gives this, he calls it living traditionalist case, if the court gives living traditionalism full weight, it defeats the method of using originalism at all. In other words, it is incoherent to treat political practices as a ratchet, moving the law in one direction against the right, but not in favor of another. Let me just make this point with the Second Amendment. Excuse me. In the Second Amendment context, the law at issue is called the New York Sullivan Law. It was enacted in the early 20th century, frankly, as a way to disarm Irish immigrants. Well, you can just be candid, that's why the law was enacted. They didn't want Irish people having guns in New York. But that law was in the books for over 100 years. And there was no serious constitutional challenge brought to the law until, after Heller. So couldn't it be argued that the New York law was actually supported by its own tradition? That there was a long-standing tradition, at least perhaps from the early 20th century, and maybe even the late 19th century, that the state had broad powers to regulate arms. If we accept this traditionalism, then New York's law might be on stronger footing than one might otherwise think. It creates another weird thing, that if the government does something that's unconstitutional and gets away with it for a long time, they will keep getting away with it, right? In other words, that the meaning of the Constitution will be affected by practice. Now, there's a couple doctrines to think about. There's liquidation, which Will Bode has written about at some length. The idea that if there's some sort of long-standing practice, that it might actually settle the meaning of the Constitution. But be careful, liquidation doesn't apply to everything. There has to be a text that perhaps is unclear. Long-standing means a practice stretching back to the founding, not something that started in the 20th century. And also, there cannot be contestation. That is, people generally don't dispute it, that once it's settled, it's sort of settled. But this problem of traditionalism does create a fork. Perhaps a leading proponent of traditionalism is Mark DiGirolamo, who's a professor at St. John's in New York. And he actually had an op-ed in the New York Times about a week ago making this point. He's basically saying that traditionalism is not part of originalism, it's something different altogether. And what he says is the court, even when they say they're doing originalism, is really leaning heavily into traditionalism. And he calls that Alito, Thomas, and Kavanaugh, among other regards. Right? And he makes actually a fair point. When we're doing original meaning originalism, as it might be said, we're looking at what people wrote and what people said. And there's a presumption there. In the 18th century, who was literate? Who was writing books? Who was speaking in various public venues? Mostly white men. Just be candid about it. And beyond that, not just white men, elite white men. Right? Those who had the words, those who had spoken, and those who had the ability to communicate their ideas. And what Mark argues is that when we focus on originalism, there is going to be an inherent, I won't say the word bias, I don't like that word, but it will lean towards a certain category of views that will be understood. Mark calls it elite, and maybe that's the right word. I don't know what the right word is. He calls it elite. Whereas tradition is something broader. It's not, sorry. Tradition is not what's been written down necessarily in a book or a treatise or somewhere else. Tradition is what's been done. And if we look to what's been done, that's a good sense of what people think the law is, or perhaps what ought to be. Okay? And in fact, he says traditionalism is even better than originalism because it allows a wider range of knowledge to be diffused through practice. You know, the common law works itself pure, as one might say, right? And this long-standing tradition actually becomes part of our law. The challenge, though, for traditionalism is what is the basis for it that we can follow tradition? It's basically an argument that if something's been done long enough, we can keep on trucking, so to speak. We can keep on doing it because that's been done before. And that creates a weird asymmetry. If there was some right that was deeply held when the Constitution was ratified, and that right fell out of favor, tradition can basically nullify an actual constitutional right that's enumerated right there in the Constitution. Conversely, let's say when the Constitution was ratified that there was never even imagined to be such a right, that people would never thought there was such a right. I can use Dobbs and Roe as an example, right? That even if some states had more lax abortion laws, there's no discussion that there was a right to an abortion. If you read the debates of the Freedmen's Bureau Act and the Reconstruction Acts and so on, no one said, we have these fundamental privileges or immunities. We have the right to speech, religion, guns, and abortion, right? That speech just never happened. It would never happen because people didn't think women had many rights back then. So what traditionalism allows, perhaps, is if there's a long-standing time where the states say, okay, we're going to protect this, it actually transmogrifies. It basically transforms a constitution into whatever majority thinks. This is why Sharif calls it living traditionalism. So if we want to sort of cabin this, I think whatever tradition we're looking to must be really old, and as Scalia said in Heller, continuous. That is, there's a tradition at the founding, and the tradition continued for many years afterwards. That's why I think in Heller, Scalia looked to the post-enactment history of the Second Amendment. He looked all the way to the 19th century. And I think Thomas did much the same. If there's this continuous tradition, I think we're on a stronger footing. Now, I have a few minutes left. In the wake of Bruen, we have a lot of litigation over how to actually apply this text, history, and tradition framework. The most famous case is from my beloved Fifth Circuit, U.S. versus Rahimi. Okay? I think we've all followed this case. It involves a very bad man, Mr. Rahimi, who shot at his girlfriend and some other people. He was subject to what's called a domestic violence restraining order, and one of the terms that you must surrender your firearms. Now, there was no conviction. He was not convicted of a crime. He was just subject to a DVRO, and he had his gun, and he was arrested under federal charges. The Fifth Circuit said there is no tradition of depriving arms to someone merely subject to a domestic violence restraining order. And in one regard, that's unquestionably true, because the idea of a DVRO is kind of a modern innovation. You didn't have these things, right? You had for sure criminal convictions for battery, perhaps not spousal battery, but there were battery convictions and the like, but you didn't have something short of a full criminal conviction resulting in deprivation of arms. This case went to the Supreme Court. It did not go well for the public defender who argued for Rahimi. It did not go well at all if you listen to the arguments. And I think what the justices were saying is, well, even if there's no tradition of DVROs, there's a general tradition that people who are dangerous can be disarmed. But there's a huge inferential leap between someone subject to a particular injunction versus, oh, he's just generally dangerous. There's a problem of generality, which Professor Schauer can talk about more than I ever will. But this is one of the challenges with traditionalism. Another case involves serial numbers. As if you've ever held a gun, there's a serial number imprinted on it. Federal law requires serial numbers. There was a federal judge in, I think it was West Virginia, well, there's no long-standing tradition of serial numbers. That's a modern innovation. Well, yeah, no, for sure it is, right? The idea of serial numbers did come around in the modern age. Now, you could just say the right to bear arms is subject to perhaps some regulations, and this one's reasonable. That would be more the Heller approach. But with traditionalism, you do look to the founding, and this is a modern innovation. Maybe the serial numbers fall out. Another one is post offices. There was a postal worker who carried a firearm in his place of employment, and he was charged with possessing a firearm on federal property. And the district court held that there's no tradition of banning firearms on federal property. Perhaps, yes, in courthouses and in schools and other specific institutions, but not federal property more generally. So one of the challenges with traditionalism is at what level of generality do we read this? Now, prediction for Rahimi, I don't know that all members of the Bruen majority meant to go hardcore in traditionalism. I don't know what they actually agreed upon. It's always sort of a black box. And I think also Justice Barrett is uncomfortable with looking to this post-enactment tradition. So perhaps Rahimi, which we decided any minute now, probably by the end of June, could provide some clarity on this issue. But lower courts in general, if they want to be originalists, I think should downplay the tradition stuff and upplay the text and history stuff, if whatever it's worth. Thank you so much. I think I'm right at time, and welcome for your questions later.
Professor Schauer.
So, thank you. I'm delighted to be here.
You got it. There you go.
There we
You're
go.
green.
Okay. Thank you again. Delighted to be here. One of the problems with April at this and most other law schools is that various people back in September have really good ideas for programs and symposia that they would like to do. Along comes November, and they say, maybe it's time to get to work on this, but then its break is coming up. So February starts, and in February they say, I guess we have to get to work on this. And lo and behold, April comes around, as it is said in the Broadway musical Damn Yankees, and every event that someone was thinking of in September all of a sudden gets scheduled for April. So I'm looking forward to this. I'm looking forward to other events taking place today, one of which I am a speaker at, so I'll be going back and forth. My invitation to speak at this was largely to speak on the question of what has happened since Bruen. In terms of what has happened since Bruen, one issue is the question, how are we to make, what are we to make of what various courts have done since Bruen? And my first thought was, okay, I'll do some real legal research, and I will try to investigate what various lower courts have done since Bruen. And I figured with the assistance of Lexis and/or Westlaw, I'd locate 15 or 20 cases in the intervening 2 years and try to see what they have done. I was off by several orders of magnitude. Since Bruen was decided, there have been 1,621 federal cases interpreting and applying Bruen, and another 286 state cases interpreting and applying Bruen. That is a total of 1,907 cases interpreting and applying Bruen. Most of those, it turns out, arise under federal or related state laws about felons in possession. If you are a felon, you're subject to a range of additional charges and additional penalties if you are in possession of certain firearms. So it turns out that there are a vastly larger number of possessing felons than I could possibly have imagined, and that explains most of the 1,907 cases. For those who are interested in doing an empirical research project, not me, on this, there's actually an interesting theoretical as well as empirical question here. So the arguments for originalism tend to boil down to, and I don't want to oversimplify, and I'm not the one to do it, given that I'm no originalist, but the arguments for original tend to boil down to two categories of arguments. One are the arguments that originalism in some form or another is fundamentally theoretically right, either as a question of constitutionalism or as a question of the nature of law, or as a question, as my colleague Larry Solom has been arguing for some years, as a question of the nature of language. But in addition to these arguments that there is something about law and about constitutions that make originalism right, there's also the argument that originalism is right and a good idea because it is judge constraining in ways that its opponents, most obviously living constitutionalism, do not recognize or do not care about. So at least one argument for originalism is that it constrains judges. In the wake of Bruen, in the wake of the 1907 cases that I've just mentioned, there is an interesting question to be asked about whether it is in fact constraining. One of the things we could do with a lot of these 1907 cases is try, as political scientists have done with Supreme Court decisions, try to get some sense of the backgrounds and previous decisions of the deciding judges to see what their views were about guns, about the Second Amendment, about gun control prior to the Bruen decision, and then try to determine whether what they have done with their 1907 cases varies from what we would predict these same judges would have done without the existence of Bruen as a constraint. I think we would learn a lot from this. I encourage someone to do this research. I don't encourage me to do this research, but I think we could learn a lot about the extent to which originalism is actually constraining. One hypothesis is that it is. Another is it just provides a justification for what the judges would have done anyway. So leaving that aside or behind, I want to focus now on an important aspect of Bruen. In doing so, I'm going to be talking largely, as was mentioned earlier, about research and analysis that I've done with my colleague, who also happens to be my spouse, Barbara Spellman, who is not an expert on originalism, neither am I, but she's a genuine expert about analogical reasoning, an extensively published and researched author about analogical reasoning. So much that we have done together about this starts with many of her insights, including what I'm about to talk about a little bit, something that we've done together, not yet published, that was done at the Notre Dame Law School, largely coming out of a research project, research enterprise at Duke Law School on firearms law. So there is a symposium about Bruen coming out in the Notre Dame Law Review, so you can read more extensive versions of what I am about to say here. Just for a reminder to those of you who don't know or don't remember, Justice Thomas in Bruen acknowledged the difficulty of applying an originalist approach across the very long temporal gap between either 1791 or 1868. The court in Bruen did not resolve that issue. And then Justice Thomas relied on the simultaneously empowering yet constraining idea of reasoning by analogy. The judicial task Justice Thomas offered was not to identify a historical twin between then and now, but a well-established and representative historical analog. And in doing so, he suggested that analogical reasoning was commonplace, an ordinary, familiar part of legal reasoning that we all know about and can all do. So that invites the question, what makes something analogous? What makes an earlier form of regulation analogous to one that might now be before the courts? What makes an earlier gun analogous to a gun that might now exist? What makes an earlier sort of firearm, even if not a gun, or arms, analogous to one that might now exist? So, as Justice Thomas suggests, courts are familiar with what they think is doing analogical reasoning. But that doesn't necessarily mean they always do it the way that Justice Thomas had in mind. It doesn't mean that they always do it well. It doesn't mean that they always do it in a constraining fashion. So we want to identify, at the very least, two mistakes. One mistake is exemplified by Justice Stephen Breyer's opinion in the rarely known and often forgotten recent case of Lozman versus the city of Riviera Beach, Florida, one of two Lozman versus the city of Riviera Beach, Florida. I'll interject here. Those of us who write law review articles as part of our living are used to the fact that nobody reads them and nobody cares about them. When I first wrote about Lozman, which I'll describe in a moment, lo and behold, I had a voicemail message from Mr. Lozman castigating me for misinterpreting what he had done and threatening to tattle on me to the editors of the Supreme Court Review and to my dean. I don't know whether he ever did that. I don't know whether it would make a difference to anyone. But Lozman, a particularly litigious character, was involved in a dispute with Riviera Beach, Florida, that related in large part to taxation. The question in Lozman was whether his place of residence, a houseboat, was a house or a boat. It turns out if it was a house, then Riviera Beach law and Florida law and all sorts of domestic property law was applicable, and the case would be decided in the Florida courts. But if it were a boat, then all of a sudden this is an admiralty case that belongs in federal court. So the Supreme Court felt called upon to decide this for reasons that are not apparent to me, to decide whether a houseboat was a house or a houseboat was a boat. Justice Breyer engaged in analogical reasoning, or so he thought, but one of the things that he did was engage in the error of superficial similarity, surface similarity, rather than deeper or structural or relational similarity. He showed us pictures of Mr. Lozman's residence, showed us that the residence sort of looked more like a house than a boat, and concluded that therefore this was a house and Florida law applied. It's a little bit unfair to Justice Breyer, but not totally. So that's one error that could be made in doing what Justice Thomas urges that we do. The other error is one that we want to describe as excess freedom or excess lack of constraint or whatever. Here, this is associated most prominently with Judge Richard Posner, also with my occasional co-author Larry Alexander, also with my former colleague Peter Weston. This is the error of starting with the proposition that any two things in the world are similar in some respects and different in others. And once you recognize that any two things in the world are in ways partly similar and partly different, then Judge Posner says anything goes. Identifying what is similar to what is totally unconstrained, and therefore, not surprisingly for Judge Posner, judges should make the decision that is the most efficient or the best as a matter of policy. That's also a mistake. It is a mistake because it ignores the way in which people tend to, and there is lots of research on this, people tend to see analogies or perceive analogies. That is, the ability to perceive an analogy is something that is primary for lots of thinkers and reasoners. And they don't think of which analogy would be the best policy, which analogy would be most efficient. Judge Posner's mistake is ignoring all of the research about the actual existence of analogical reasoning by going from one particular to another without the intermediate step of going to a higher level of abstraction. Moreover, when people actually engage in primary analogical reasoning, and primary is a little bit of a misleading term, but when they do this, they are strongly influenced, the research that my co-author has done, strongly influenced by their own backgrounds, their own experiences, their own knowledge base, and the like. Therefore, if we apply this to the question of guns and gun control and the Second Amendment and weapons, we would want to know what judges, not as a group, but individually, what do judges know about guns? What do they know about firearm control? What do they know about history? What do they know about a whole bunch of things? And given that this varies among judges, this is going to determine what they see as analogous and what they see as disanalogous. The ability to do an analogy, the ability to see analogy, is likely to be as a result, far less constraining and far more judge variable, given the variability of knowledge about guns, gun control, history, and much else, far more variable than Justice Thomas imagines. So there's another research project that would come out of this, one more research project that somebody, not me, ought to be doing, trying to examine what it is about the judges that are applying Bruen that may influence which analogies they see and which they don't. What do we know about whether judges have experience with firearms? Some have it. Most are likely not to have it. One of the things that I have discovered as being one of the few people around here old enough to have been drafted, I have fired a fully automatic assault weapon, not a common experience for judges or anyone else. What do we know about what judges know about weapons? What do they know about the history of firearms regulation? What do they know about the history of 1791? What do they know about the history of 1868? All of these things are going to influence what judges see as similar, what they see as analogous, what judges perceive as disanalogous, what they perceive as being totally different. If this is part, as Justice Thomas tells us, if this is part of what it is to look not for a historical twin, but a relevant historical analog, then we cannot know what judges are going to see as a relevant historical analog without knowing more than Justice Thomas imagines about the judges, about their backgrounds, and about their experiences. That may in turn suggest that reasoning by analogy, however commonplace Justice Thomas claims that it is, may be far less constraining than originalism in its full glory suggests. I will leave it at that and turn the floor over to my colleague, John Harrison.
Thank you, Professor Schauer.
Thank you. Fred's story about, I'm going to call it, the city of Riviera Beach in order not to mispronounce the name of a highly litigious individual has me wondering whether I'm going to be getting an email from the ghost of William Marbury saying that I've been misunderstanding his case for all these years. But I'm not going to talk about that case. I'm going to talk about Bruen, in which the Supreme Court took the question to be whether the Second Amendment should be applied with the kind of scrutiny means-ends test that the courts have developed in other contexts, or with something else like looking to text history and tradition. And you know the answer, they said, look to text history and tradition. And I'm a law professor, so of course I think they asked the wrong question. A better question would have been, what is the right to keep and bear arms? Meaning, what kind of thing is it? The court says it's a pre-existing right, which seems to me to be going in the direction of answering the question, but only in the direction of answering the question. By calling it a pre-existing right, I think they meant that it is some kind of legal phenomenon that was known when those words were put into the Constitution. And the next question I'd like to ask is, what kind of legal phenomenon? I'm going to offer three possibilities, and the court didn't talk about any of this, and as I say, one of my complaints about Bruen is that they didn't talk about any of this, although I'm also going to talk about whether that's a legitimate complaint when I get there in a couple of minutes. But the three possibilities, of the three possibilities I'm going to discuss, two are drawn from a First Amendment case. The First Amendment and the Second Amendment do have certain textual, pardon me, Fred, analogies. They both refer to something called a right, the right of the people to keep and bear arms, the freedom of speech, the right of the people peaceably to assemble and petition for the redress of grievances. Those are two of the appearances of the word right in the Constitution. The First Amendment case I have in mind is especially interesting. It's from the 1980s. It's from the D.C. Circuit. It's called Ullman against Evans. It is a case about the constitutional limits on the law of defamation, one of the interesting things about Ullman against Evans is that Evans had said that Ullman was a communist, and that was not the defamation. Ullman was a communist. Evans also said that Ullman, who was a professor, had no standing in his profession, and at that point, Ullman took umbrage. Being called a communist was just, well, he was a communist. That produced a D.C. Circuit en banc decision about the relevance and the application of the old, is it fair comment? Is that, right, is it fair comment to say that somebody has no standing in his profession, which is, as I say, old. I'm not sure just how old, but pretty old. But its age figured in the exchange between two of the judges, one of whom said that the First Amendment should be understood as a collection of reasonably determinate legal rules that existed at the time of the First Amendment. So that's a candidate for something like the freedom of speech, the freedom of press, or the right of the people to keep and bear arms to be. What kind of thing is it, as I say, if it's some kind of legal phenomenon that was known to exist at the time of the framing? It might be a collection of rules. Not surprisingly, guess who took the position that it's a rule? Judge Scalia, who one of those people who tended to find rules a lot. And perhaps that tells us something about the constraining effect of text, that Justice Scalia tended to find that texts were rules. His exchange was with another D.C. Circuit judge who took the position that the First Amendment announces a principle, that the idea of the First Amendment is to achieve a goal, that the goal is to make sure that there will be free and open political debate, and that the more concrete rules, like the rule of fair comment, may need to be adjusted over time in order to achieve the goal of the First Amendment, because the content of the First Amendment is this goal. And I will say the judge who said that had a tendency, when he saw a legal norm, to find a goal rather than a rule. But his thinking is especially interesting because some years before he wrote his opinion on Ullman against Evans and Novak, he invented originalism in an article called Neutral Principles and Some First Amendment Problems in 1971. Judge Bork believed in principles and tended to think that law consisted of principles, goals, maybe because he started off with the Sherman Act, and that's how he understood the Sherman Act. Those are two possibilities, two things an existing right might be. I think that Bruen raises a third possibility, as far as I know, continuing to be under-theorized. Maybe the pre-existing right that was referred to in 1791 was a tradition. What's a tradition? The thing that I think would distinguish a tradition from either a set of relatively concrete rules or a goal, a normatively guiding point to be achieved, again, which is Bork's understanding of the First Amendment, I think it would be that a tradition is a feature of a tradition is that it is dynamic. That is to say that it evolves as common law principles evolve. As new questions come up, the people who are administering the tradition answer the new questions, usually on the basis of analogies, and they can do that better or worse, as Fred was telling us, but usually on the basis of analogies. They answer the new questions on the basis of what has gone before, but in doing so, they add to the tradition. In doing so, they create another step in the body of practice. And if the body of practice is what something like the right of the people to keep and bear arms is, then it seems to me that it can have this kind of evolutionary character, this kind of dynamism, and that would be a reason to look for developments after the point at which the thing, whatever it is, the pre-existing right, is named precisely because it has built into it this kind of dynamism. As I say, the court did not talk about any of this in Bruen, and certainly, as far as I know, there has not been a whole lot of thinking about what sort of thing a tradition is and when it is that legal texts refer to a tradition. And the next thing, that's the part I think is actually interesting. The next thing I'm going to say is, as I keep saying, the court did not get into this, and I said I was going to say something about courts as institutions, and it's not surprising that the court didn't get into this. Nobody talked about it to them. The way the American judicial system sets up questions for appellate courts, and in particular the Supreme Court of the United States, is not necessarily going to satisfy a law professor. It is going to be a process of concrete disputes coming up, and by concrete disputes I mean not only particular cases, but frequently over a series of cases like the 1900 plus cases that Fred can. We're gonna have to throw him out of the law professor guild. That was actual research. That's cheating. You're not supposed to be doing that. Anyway, when I say concrete disputes, I mean the specific kind of problem that arises in the administration of the law that might arise in a whole series of cases or controversies, something else you could call a concrete dispute. That's the sort of question that comes before appellate courts. That's the sort of question that comes before the Supreme Court of the United States. One thing that the law professors are talking about these days is how much is the Supreme Court and how much should the Supreme Court? I think this applies to all courts, but of course everybody talks about the Supreme Court. How much are their decisions properly constrained by the issues that the parties bring to them? The buzz phrase for this these days is party presentation. As a practical matter, the answer is a lot. Whether the answer ought to be a lot is another question, but if the answer ought not to be a lot, then the next question is, how is the institution going to change to that, given that it is a court that decides cases primarily through the representations of the parties, and then in the Supreme Court of the United States these days, in high-profile cases with the addition of a stack of amicus briefs from law professors that let's hope nobody reads. But the institutional modes of operation of courts, and in particular for this country, the Supreme Court of the United States, are of course overwhelmingly important if you're interested in sort of the concrete law, and if that means that what a law professor thinks is the most important question is going to get missed, well, sometimes the most important question is going to get missed. I will say one thing about analogies and Justice Thomas and the court having to do with, since my sort of subtopic now is the operation of the institutions. Which questions about deciding by way of analogy, which questions should be treated as questions of law and which questions should be treated as questions of fact to be decided perhaps differently, because this is the way the system works, perhaps differently in different cases. Because as Fred was describing what research about analogy has told us about just how much people's subjectivity matters when they draw analogies, when they decide what is like what, I was thinking about juries deciding whether something's negligent. They look at their ordinary experience. They are told, do you think this was a reasonable precaution or not? They look at their ordinary experience. They apply what somebody now would call their prior probability assignments about how likely is it that this happens, how likely is it that that happens. That's the sort of thing that, why put questions like that to a jury? Because just by living ordinary life, they develop the sort of experience that intuitively gives them the answer, yeah, this is the sort of thing that happens and this is the sort of thing that doesn't happen. And what Fred was talking about is, guess what? People vary in that. And if you ask 12 people, for example, on a jury, they're all likely to have slightly different answers to, is this the way the world works? Is this the way people operate? How likely is this story? Can we believe this witness? Or is this something that just doesn't happen and the witness is stretching the truth? That comes out of people's experiences. It's going to be to some extent subjective. The way the legal system allocates the use of those subjective bases of decision is in large part by saying some things are fact and some things are law. Maybe a question that analogies, traditions, cases like Bruen suggests is maybe more questions should be treated as questions of fact than as questions of law. The back part of that I want to say about, because Fred was sort of assuming that a lot of these questions of analogies under the Second Amendment are going to be decided by judges as opposed to by courts and by appellate judges, and what was Justice Thomas thinking about. The other thing I want to say about the institution, and this is true both about the justices of the Supreme Court and people who write about them, is that thinking about American law tends to be very Supreme Court centric. And so when Justice Thomas talks about applying analogies, he's thinking about himself applying analogies. He's not thinking about 1,900 cases being decided in a whole bunch of state and federal courts, and he's certainly not thinking about, well, which of these issues should go to a jury. I think, as you can see, maybe some of them should go to juries, but that's the kind of question that a Supreme Court justice is not likely to think about just because of the perspective they have they think of questions of law, they think of themselves as deciding questions of law, so they think ultimately these questions of analogy are going to be decided by, guess who? By them. The last thing I'm going to say, since we're talking about history, tradition, and development over time, is that the question that I raised about the Second Amendment, what kind of thing is this, would have been a hard question in 1795, because even though people had been talking about the right to keep and bear arms for a couple hundred years by then, they had not been focusing on this particular aspect of what they were saying. And so when somebody has the question, like a judge or a law professor, the question, what is it they were talking about, often the things people said about what they were talking about are going to be of only limited use in answering the question because they weren't thinking about that. They were just doing it. They were not asking the questions that somebody 4 years later, I said 1795 for example, 4 years later might have needed to know in order to apply their principle. That's not about the distance of more than 200 years. That can happen in 4 years. So a lot of the problems that come up with originalism are not, despite sort of what you might think from a lot of the debates about originalism, are not about difficulties that arise from a long lapse of time or even a substantial lapse of time. Here is a great example for another part of the Constitution that's been in the news recently, Section 3 of the 14th Amendment. Here's something the drafters of the 14th Amendment were not thinking about. The question is, what about the people who are subject to the 14th Amendment Section 3 disqualification and are in office right now? Are they automatically removed, or does it take some proceeding to remove them? That's the question that came before Chief Justice Chase on circuit 2 years later. 2 years later, no long lapse of time, but he didn't have much guidance from the text or the history of the 14th Amendment, because the questions that people are thinking about at the time something becomes law do not include all the important questions that arise when it's going to be applied, and that can have nothing to do with the fact that it's more than 200 years ago. As I say, that happened 2 years later. So the question, I'll conclude by saying, the question, what is the right to keep and bear arms? What kind of thing is it? Is an important question, is a difficult question, would have been a difficult question in 1795.
Thank you. We'll have a few minutes here for our panel to interact. I think we might just kick it off by exploring the idea of whether tradition and analogy is really constraining on judges.
I like to think that tradition can have some constraining effect to the extent that it actually is a tradition, which is a difficult thing to determine altogether, right? Look at Glucksberg, right? When you're trying to determine if there's a substantive due process right, that should be protected, we ask, is it deeply rooted in our nation's history and tradition? How deep must it go, and what does actually rooted mean? I don't think these are obvious questions. And I think even in Glucksberg, it depends on the level of generality. That's why the second step of Glucksberg is it specifically defined? And if the right is specifically defined, it becomes a lot harder. What that does mean, though, is that only old rights can have this sort of traditional provenance, and more modern rights will necessarily lack it. So the constraint sort of depends where you sit, where you stand, right? If you're looking to sort of have courts enforce robust modern or postmodern rights, then traditionalism is harder to work with. I'll let Fred talk about the analogical reasoning one, but I do want to mention the point of party presentation. This is an important issue in originalism more generally because of stare decisis. Let's say you have a decision from the Warren or Burger courts, and there were no originalist arguments presented there. Could those judges be expected to make originalist opinions? So the classic example is Brown, sorry, in the Virginia Law Review, right? Judge McConnell wrote about this many years ago. There's an argument that Brown is originalist, maybe you agree or not, but no one presented those arguments to Earl Warren in the 1950s. So maybe even the decision itself is not originalist, it can be justified originalist ground. Conversely, if there's a non-originalist decision in which there was no originalist arguments presented, has that affect the stare decisis analogy? Last point on party presentation. In Bruen, Justice Thomas basically made up the analogical reasoning approach. Not a single lawyer, not a single lawyer briefed this issue. I don't know if he got your article from a stack somewhere, I'm not sure. Barbara, I don't know where he got your article from, but as far as I recall, this is something that Thomas sort of cooked up internally. I think he was just very annoyed at scrutiny. He didn't like it. He thought lower judges were abusing it. He said, okay, let's go back to the LSAT. Let's do some reasoning. Didn't the LSAT just drop reasoning? I'm not even sure. But I think they did. But I think for party presentation, when judges start making up originalist methodologies that no one's vetted and that, as far as I know, not a single originalist actually likes, you know you're on shaky ground.
And it is. There we go. I mean, as we think about the implications of Bruen, one dimension of that John hinted about was how do we know what a case stands for? And moreover, when a case is decided, does the deciding court know what it will stand for? So here's another actual numerical statistic. In its most recent term, the Supreme Court decided, after briefing, after argument, with full opinion, 57 cases. That is down from about 130 a year as recently as the late 1960s and early 70s. Why this is? People are speculating. One hypothesis is that now that Supreme Court justices have 4 law clerks each, opinions are getting phenomenally longer, and when you write longer opinions, you can't write as many of them. But that's a somewhat snarky observation about the fact that the court is deciding fewer and fewer cases, and in the process, giving less and less guidance to lower courts. That insofar as lower courts are expected to follow what higher courts and highest the Supreme Court say, one might expect the Supreme Court to be increasingly attentive to their guidance giving function. They're not. More and more we find case-specific or fact-specific opinions that provide far less guidance, far less illumination to the lower courts that are expected to follow them. Now, that may be a good thing, it may be a bad thing. John and I differ here. He thinks it's probably a good thing that the Supreme Court, to use the modern vernacular, stays in its lane and just reaches decisions about particular cases. I am inclined to think that the Supreme Court has very significant lawmaking functions, whether people want to admit it or not. And if they are a very significant lawmaker, then they ought to think about making law as effectively as they can. And they also ought to think about, and this is a more difficult question, the empirical field against which they are making the law. That is, what are the problems that are actually arising in the world? Nothing in Supreme Court procedure, with the possible exception of the occasional amicus brief, nothing is designed to give them the kind of knowledge that one would want a lawmaker to have in order to make laws that are going to govern hundreds or thousands of different kinds of cases. A differently constituted, a differently structured Supreme Court decision-making process would perhaps make it easier for the court to get the kind of information it needs before it makes a rule. What are the cases? What are the events? What are the controversies? What are the situations that this rule is going to cover? Without knowing that, either they're just guessing or they are relying on the mysterious and commonplace nature of common law reasoning to make it up as they go along.
I have three thoughts. The first, I guess two of which are going to respond to what Fred was just saying. The first of which on the specific question, can analogies and traditions be constraining? The answer is yes, they can, but you can lead Richard Posner to water and you can't make him drink. That is to say, somebody who wants to be constrained can be, and it better be true, in particular, that analogies can be constraining, because that's how human categorization works. That's what people do when they decide, is this thing in the road a car or not? And that, apparently that works. So it is possible someone who wants to use that faculty can use it. The second point about interesting. This is just an anecdote, but it is about the institutional operation of the courts, and particularly the institutional operation of the Supreme Court, and it's about Brown against the board and what the justices knew about the original understanding. Felix Frankfurter assigned one of his law clerks to do extensive research on the original understanding with respect to the school segregation. The law clerk, like a lot of Frankfurter clerks, later became a law professor, was Alexander Bickel, who was, some of you will recognize his name. He was, one reason I know about this is he was Judge Bork's best friend. And Bickel wrote one of his early articles based on the memo that he wrote for Frankfurter. That article was a major influence on Bork's thinking about the 14th Amendment and equal protection. I will say, so I think this, like a lot of stories, this is one that cuts both ways, because on one hand, yes, the Supreme Court did have, at least internally, some information about the original meaning, the original understanding, the original intent, whatever they were thinking about in the 1950s. I will also say that, as great an intellectual as Alex Bickel was, his work on this particular question is, I would say, very much been superseded in subsequent decades. The last point, Fred raises the question, so the Supreme Court be deciding more cases. And my general reaction when somebody points out that the Supreme Court is not deciding as many cases as they did under the Berger Court is to say, you see, there is such a thing as progress. America is getting better. What I think though, if the court were going to try to perform the function that Fred wants them to perform, the way to do it would be for it to be more like in the 19th century when they didn't have discretionary jurisdiction. And they decided hundreds of cases every year. Some of them were 2 or 3 pages long. Because it is really, that's the thing about the future. You don't know what's going to happen. It is really hard for a court deciding a case, especially on the basis of the limited body of information the court has before it, to know what the next question is going to be. And so I think one good thing appellate courts can do, and one good thing that the courts of appeals do, is just decide a whole lot of cases and say, these are the facts, very briefly, this is why it comes out on these facts, and accumulate a collection of experience rather than 10 monster opinions with subparts and multi-pronged tests, which are obsolete in 5 years.
That might suggest that the federal courts of appeals that have to decide all the cases that come before them are another interesting research project out there. Increasingly, as you all know, they decide many of those cases without opinion. You can read them in the tables at the beginning of the Federal Reporter, but that at least suggests typical federal court of appeals is going to know a lot about the kinds of decisions that they are making, more so than we'll get from the Supreme Court with its discretionary jurisdiction. So, as I mentioned at the beginning of what I was saying, there are a vast number of possessing felons out there who raise Second Amendment objections to what turn out to be very serious consequences of being a felon in possession. That minor felonies produce sentences either because of sentence enhancements or charging enhancements that produce sentences of 2 years to 10 years more than they would otherwise be. Most of these people, with the exception of the ones connected in some way with organized crime, most of them have appointed counsel from federal legal aid operations that are pretty sophisticated. So we've got lots of sophisticated arguments out there about what the Second Amendment means, what all of this means in the context of felons and possessions. We should be looking not to the Supreme Court, but we should be looking to federal courts of appeals that are dealing with these cases on a daily basis. What have they determined about all of this, given that they deal with these problems and have a better sense of what the issues and problems are than the Supreme Court, even with all of its staffing, is likely to get.
Let's open it up for audience questions.
So when we write about this, it turns out that one of the examples we use comes from a little bit of my knowledge about the First Amendment. An example of the fact that analogizing is knowledge dependent. If you ask the ordinary person on the street, what do civil rights demonstrators and Nazis have in common? Some of them are likely to say nothing. Some of them are likely to say, that's really an offensive question. If you ask that question to someone who knows about the First Amendment, they are likely to say, it turns out that civil rights demonstrators in the 1960s and the American Nazi Party are central actors in understanding the rights to picketing, demonstration, and marching under the First Amendment. They will see an analogy, they will see a similarity that ordinary people will not.
We're not ordinary.
Right, that will not see. So I don't think we see in at least the other parts of the Constitution that I know a little bit about as explicit a reference to analogical reasoning. But I think it does go on, and if I were to look for someone who actually can give a better answer to your question, I'd ask it of someone who specializes in the Fourth, the Fifth, and maybe the Sixth Amendments. Again, in terms of volume of cases, volume of issues, and everything else, criminal procedure cases under the Fourth, Fifth, and Sixth Amendments are vastly dominate in terms of volume, First and Second Amendment cases. If such a thing exists in other parts of the Constitution, that's where we are likely to have it.
In the back.
One thing that I think has been different about the Second Amendment cases, as opposed to, say, a First or Fourth or Fifth Amendment case, is the degree to which there is disagreement over the very core of the right. You know, if you had a ban on political speech, I don't think you would have a 5-4 decision. And I'm wondering, maybe I'm wrong about that, but I think there's a kind of split on the very core that is not true for a lot of the other amendments. And I'm wondering if you have any insight on why that may be. Is it a problem with reasoning, with an ideology issue? What makes the Second Amendment so difficult for consensus, even on the very core?
Manish Nahalal has that. Why is this right different from other rights? Sorry, sorry. Paysock is
Some
next
of us
week.
will get that.
I wrote an article 10 years ago that began with that first sentence. Why is this right different from other rights? And I can get an entire thesis on this one. Just a short answer in the interest of time. I think a lot of people like political speech. A lot of people don't like guns. I don't think that's a controversial statement. I think a lot of people just don't like guns. They don't see a need for them. Heller did not emerge until 2008. So for basically the entire existence of everyone's adult life, the idea of a Second Amendment was, you know, not a real thing. Maybe for scholars like myself and Robert, we had views on this, but most people thought this was not a real thing. The entire 20th century lapsed before the court provided any protection. And I think there's a reason for that, because the judges in the court were presented with Second Amendment cases, and they just didn't see much weight in them. It really took kind of a shift in intellectual culture, which has been written out a lot in the 1980s, that perhaps changed that dynamic and led to Heller. People like Joyce Malcolm and others who wrote about it. But you really need to change the culture. But even in the wake of Heller and Bruen, I think we've seen resistance from the lower courts. I think there's a Ninth Circuit rule that says any decision favorable to the Second Amendment is immediately en banc. It's an automatic rule, and there are many judges who just view it in that fashion. Even the Supreme Court, after Heller, they sat by idly for 12 years, where letting every single lower court basically walk over Heller. And I think Rahimi will basically walk back Bruen, and I don't know if the court will take many of these other cases involving the violent felons, the 15 million cases that Fred found. I think so will be cert denied. So, you know, even though Heller and Bruen were very large symbolic victories, I don't know the court's actually committed to making this a right of such significance as political speech. Halal Haza. Thank you.
Yeah, and it's also possible that a fair amount of what you ask about is explained by the so-called selection effect. Are we influenced by the cases that wind up on appeal? Are we influenced by the small number of cases that the Supreme Court takes? So everything that you said about the Second Amendment would have applied to defamation in 1964. Then the Supreme Court decided New York Times versus Sullivan. That settled the issue until about a year ago, when Justice Thomas thought that we ought to reconsider New York Times versus Sullivan. But I think for a long time, even this issue at the so-called core of First Amendment political speech was thought of for a long time as either a non-issue and then settled. So a lot of this depends on what gets litigated, what gets appealed, and so on. And just as defamation for a long time was thought clearly outside of the First Amendment, I think much the same applies to the Second Amendment until recently.
I have a suggestion. Since we're handing out empirical research assignments, here is an empirical research assignment. See what the lower courts do in Seventh Amendment cases, in which the Supreme Court's approach is, which has a large historical component, is pretty fuzzy and gives them a substantial amount of leeway, because I strongly suspect that there are lots and lots of judges in the lower courts who aren't such big fans of the Seventh Amendment and don't think the civil jury, probably most of them believe in the criminal jury, but have serious doubts about the civil jury. And I wouldn't be surprised, this is law professor empiricism, I would not be surprised if in fact the Seventh Amendment civil jury right is another one that doesn't really have sort of everybody's buy-in, and that might be reflected as a practical matter in the way these often borderline questions, like especially under federal statutes, are decided as to whether there's a jury or not.
And the non-buy-in may be supported by the views of the rest of the world. The number of countries in 2024 that, with the occasional tiny exception, have civil juries is, to a first approximation, 0. That says something about the popularity of that which the Seventh Amendment allegedly enshrines forever.
And there is, in fact, a Seventh Amendment Foundation created some years ago by some trial lawyer who has been trying to, beat the drum and say, this is a great American tradition and you should feel about it the way you feel about the freedom of speech, and it's not working.
Make the Seventh Amendment great again.
Thank you all for coming. Please join me in thanking our panelists.
Thank you, Fred.
Thank you. This is great.
Glad someone got my Passover joke.
Thank you very much, Professors Harrison, Schauer, and Blackman. Our next panel will begin in about 5 minutes, but feel free to grab another pastry and some coffee, and we'll begin shortly.
So I actually know